Good afternoon, everyone. It's Paul Tilley, and welcome back to HN1100. Today, we're going to be looking at Chapter 11, which is the grievance process. Now, how does the grievance process work? What exactly is it? Well, let's do a little timeline on this. We were negotiating a collective agreement. Okay, we went through the process, and with maybe some third-party help, maybe we did it ourselves, we reached an agreement with the employer. So the union and the employer have reached an agreement. Now, we are now operating under what's called a contract of employment that blankets everybody, hence the word collective. So that contract says certain things in it. It says that the union will do certain things. It says that the employer agrees to do certain things. So the question is can everyone follow that contract to the letter for the term of the collective agreement? Odds are that's not going to happen. Odds are someone's going to dispute something, or the interpretation of a clause in the contract is going to be different from one perspective than another perspective. So how do we resolve disputes during the term of the collective agreement? What happens if someone says, my rights were violated? How do we resolve that? And this is where we run into something called the grievance arbitration process. And what the grievance arbitration process is it deals with, under the terms of the collective agreement, there are certain rules. We need to be able to enforce those rules, and this grievance process allows for the proper enforcement of those rules and to redress any wrongs that were committed. So, let's take a look at the notes. First of all, the collective bargaining that goes on will result in one of two options. The first option is an agreement, and the second option is no agreement, and we end up with some sort of a strike action or a lockout. 95% of the time we end up with an agreement that allows for the business to continue. We'll look at the strike action option a little later on, but for now we're assuming that our collective agreement has been concluded successfully and that we're operating under the terms of the collective agreement. So what we're going to do in this unit is look at this issue of grievances and how grievances are managed inside of a collective agreement. First and foremost, we need to note that trade unions negotiate collective agreements with the employer. They do this on behalf of their members. Thank you. They do this on behalf of their members, and the union then will enforce the terms of the collective agreement on the employer. Likewise, the employer will enforce the terms of the collective agreement on the union. The collective agreement tends to be very prescriptive. In other words, there are things that we can and should do. So that process then has to be backed up somehow, or how are we going to enforce that, making sure things are done? Well, the grievance procedure and the grievance process ensures that disputes are resolved quickly, easily, and without any stoppage of work. Because one of the things that happens inside of a collective agreement is once it's reached, the union cannot strike the employer, nor can the employer lock out the union. So we have to have some mechanism in place to resolve disputes. That will invariably happen. So grievance arbitration looks really much at rights and what are the union's rights and what are the employer's rights, and it tries to balance those. The term grievance really describes an alleged violation of the terms of the collective agreement. If it's not in the collective agreement, it cannot be grieved. So we need to be able to ensure that if there's a problem, it's a problem in interpretation of the terms of the collective agreement. Now, it's far more common for the union to file a grievance against the company than it is the other way around. So generally we look at it from the union filing a grievance. Grievances fall into a number of categories, or they can be filed under a number of categories. First, we look at an individual grievance. I'm working for you. We have a collective agreement. You tell me to work overtime but not pay me. I look at the collective agreement, and the collective agreement says, first of all, we get paid for overtime, and second of all, I'll get a time and a half. Okay, so as far as I'm concerned, you have broken the collective agreement. What do I do? Well, the grievance procedure gives me a process to resolve that issue. That's for me. We could also have a group grievance where a bunch of people in the organization, a bunch of workers, feel as if they've been wronged. The interpretation of the collective agreement has wronged them, and they can collectively file a grievance against the company. We also have something called a continuing grievance. And it may not involve a single incident, but a series of incidents where the collective agreement was broken somehow. So it's very similar to a group grievance, but it has a longitudinal factor, a longer period of time. And we also have a policy grievance, which alleges that the employer's actions or lack of action is a violation of the collective agreement. So, grievances happen. How do we run the process? How is the process for resolving them? Well, first and foremost, there are timelines. So grievances need to be taken care of quickly. Okay? So timelines exist. So a grievance commences when the affected individual or group knows or ought to reasonably know that there is a violation of the collective agreement. The union must be notified as soon as the individual or group is aware of the violation. So as soon as I find that I've been wronged, my job is to tell my union, and the union then can move forward at getting it resolved. If notification is not immediate, there may be some difficulties in pursuing the grievance. Time goes by. If it's not timely done, then someone will argue, well, it wasn't that much of a problem, so why is it you're bringing it to us now? So the actual grievance is a process. It is a tiered process that allows for progressively greater actions, okay? Like, let's say, for example, you tell me to work overtime. The collective agreement says, well, yeah, I have to work overtime, but I also have to get paid for it. And I have to get paid at time and a half. So you tell me to go work. There's no talk of getting paid. Maybe it's a simple misunderstanding rather than a serious violation. So what the grievance procedure allows for is resolving these little problems quickly and dirtily before they get into a major expensive grievance. So my first step is to file an actual complaint about the violation. I can do it orally. I can go speak to my union representative, or I can write it. Normally these things are written down for the sake that we have a tracking. So me making that complaint is I am the griever. And the griever is expected to continue work. I might have a problem, but I still have to continue work. The grievance has been noted, duly noted. I could do my job, and then it will get resolved after the fact. So the idea is to keep continuous work going on. The other party, the employer, has to respond to my grievance within a certain number of time. Usually it's within 2 weeks. If you don't respond, and we can't resolve the issue, just the two of us, my employer and me, then it moves on to a next step. So after a formal written grievance is submitted, the union and employer then investigate the facts surrounding the grievance. Once the investigation is complete, the shop steward, which is a union person, union representative, or a grievance committee, meets with management. So if we couldn't resolve the issue in that first couple of weeks just by talking about it, it goes to a next level. So a shop steward gets involved, a manager gets involved, both sides present the evidence, and they attempt to find a solution to it. Again, a little more people involved, a little more intricate. A resolution at this point often happens, but if it doesn't happen, it goes to a next stage. The union and management then will try to resolve the issue by moving it up the chain of command. Sometimes they'll bring in a third party, and a failure to reach a satisfactory settlement leaves the parties with an option for something called arbitration. So we try to get it resolved between us, but if we can't get it resolved between us, we can bring in a third party who will listen to both sides and make a decision. That decision will be binding on both of us. So the process then has this steppingness to it. We'll try to resolve it amongst ourselves first. If we can't resolve it around ourselves, we get more union, more management people involved. Eventually then we'll work our way up to getting an independent third party coming, called an arbitrator, who will decide on the decision and make a ruling. The arbitrator, he or she makes a decision, that's binding. So in other words, both parties have to accept the results. And the arbitrator, is an expensive thing. So unions and management don't like things going all the way to arbitration. They want to get the grievance resolved as quickly as possible. So there's an incentive there to do that. The arbitrator, if the arbitrator does get involved, the arbitrator has similar powers to a judge, subpoenaing information, getting people to come in, taking statements, these sorts of things. A proper judicial type hearing. And once that's done, then the arbitrator will make a decision. As I say, that decision is binding. Very similar to a court system, there has to be a reasonable degree of certainty that the incident occurred as it did before anyone can be accused of anything. So the arbitration process can be a very lengthy, time-consuming, expensive process. As I say, getting this quasi-judicial process rolling costs companies and unions thousands and thousands of dollars. So the idea is, can we resolve these problems before they go to arbitration? So arbitration is usually a last resort. The award that the arbitrator can give could be anything from monetary to time to one getting their job back, these sorts of things. So the arbitrator has this right. Arbitration does take some time. In order to get someone to come in and do an arbitration hearing, it takes time for that to happen. The person has to listen to the concern, has to write a report on it. It all takes time. Someone's going to win and someone's going to lose. So this process then, as I say, creates a judicial type decision. Over the last number of years, companies looked at that and unions looked at that and said, grievances are costing a lot of money and taking a lot of time. What can we do in order to cut the cost of grievances, get these decisions reached more quickly, cause less strife in the workplace? Well, there's been some thought about something called expedited arbitration. And expedited arbitration means that we just simply speed it up. So the process is designed to be faster, less expensive, less formal, and less legalistic than traditional arbitration. The process generally deals with a specific issue and results in a non-precedent setting award that's shorter and less legalistic. So again, arbitration can be sped up. We also have another thing called grievance mediation, where we bring in a mediator who will get the two sides together and see if we can come up with a mutual agreement to the problem. So grievance mediation is becoming more popular, but it still requires that third party to come in. During a term of collective agreement, the grievance process, as I say, is absolutely critical, and it helps smooth the workplace and ensure that people are happy and good and keeping the workplace a decent place to work. So if you have any questions on that, please let me know. Thanks a lot.